Welcome to Miranda Warning's Roundtable, discussing legal issues and current events. I'm joined on the Roundtable by Liz Benjamin and Professor Vin Bonventre. Liz is the Managing Director at Marathon Strategies, a public relations and communications firm, and former host of Capital Tonight, a political and policy show focusing on New York State politics. And Professor Vin Bonventre, Distinguished Professor of Law at Albany Law School and publisher of the New York Court Watcher, devoted to commenting on the U.S. Supreme Court and the New York State Court of Appeals. We're back talking about the Supreme Court of the United States. We've had a little bit of a layover on Miranda Warning's Roundtable. We're happy to be back to have Liz Benjamin and Vin Bonventre to talk about the United States Supreme Court. Vin Bonventre has just written an article that's going to be published in the New York State Bar Journal about the Supreme Court. And I want to talk this week about what's coming up. But before we do that, your article talks about what we've had in the Supreme Court and what that means. And I think we can use that as a foundation to start the discussion about what we can expect going forward. So Vin, why don't you tell me, you've written a wonderful article that I think everyone should read about the Supreme Court over the last year, and see if you can condense that to like a 8-second soundbite.
So yeah,
he lays it on thick, and then he's like, "Oh, and by the way, 8 seconds ago. Oh, sorry, I just took 2 of them. Now it's 6."
Great article. We'll give you 8 seconds. Okay. So, I mean, what we're talking about is Trump's appointment of Amy Coney Barrett to replace Ruth Bader Ginsburg. And so Amy Coney Barrett sat on the court in the October 2020 term. So there's been 3 terms with her on the court. And the difference between the two and the difference at the court since the time Amy Coney Barrett replaced Ginsburg has been absolutely profound. I mean, we know the big cases, the Dobbs case, no more right to choose. The Students for Fair Admission, no more affirmative action. 303 creative, religious objections defeat a civil rights law. I think that's the first time that ever happened. Kennedy versus that school district, the coach that, goes on the middle of the field with the football players, and the court said that's perfectly fine. Then we have the New York Rifle and Pistol Association, the New York gun regulations, strike that down. The Environmental Protection Agency, look what the court's doing to the Environmental Protection Agency, stripping that court bare to the bare minimum of the power it could possibly have. Biden versus Nebraska, the student loan decision. Now, what Biden wanted to do, that's out. One that not too many people are talking about, the Vega v. Teco case, where the court said, oh, by the way, a 1983 cause of action when somebody's constitutional rights have been violated. Oh, you can't complain about your Miranda rights being violated.
I appreciate the shout out. Thank you.
Yeah. They did
what
name.
Is this, Vin? This is a table of contents or what?
No, I mean, look,
what's the bottom line? Where are we?
These are profound changes. So when you hear commentators, some will say, this is the worst court we've ever had, or others, this is the best court we've ever had, or the latest one I read in the New York Times, oh, this isn't the 6-3 court. It's a 9-0 court. Yeah, it's 9-0 on cases nobody cares about. But on the ones people care about, the ideologically charged, the controversial cases, the crucial cases, the ones that tell us what we are as a country, the court's been divided by and large 6-3. Every once in a while, and you know this well, the 3 liberals on the court will get Chief Justice John Roberts, and they'll get Brett Kavanaugh. And we have had a few important cases where those two did join the liberals. But by and large, on the big questions, it's 6-3.
Yeah. So, all right. So let's talk about that, Vin and Liz.
I'm sorry I went over 8 seconds.
You way over 8 seconds. And quite honestly, I'm not sure where you ended up with that. That was just like a table of contents of all
Okay,
the
well,
cases.
I'm not talking
But
about whether this
look,
is a good thing or a bad thing. I'm just saying these are the facts.
We've got, I agree, right? I mean, conservative, liberal, it's a 6-3 court, but there's a lot of cases that are coming up that are not always conservative liberal. Those are the ones that get the attention. I want to talk about the important cases that are coming up that are not getting the attention, that are going to change how people's lives are impacted. I want to ask Liz something. You know,
You see, he's had enough of me, Liz.
I have had.
So,
It's funny. I missed you. And now I wonder why. So, Liz, you wanted to talk about ethics. You wanted while we are on our hiatus, the Roundtable hiatus. There's been a lot of issues regarding ethics on the Supreme Court. I know Amy Coney Barrett has talked about it. Liz, what's your thoughts on the Supreme Court's issues regarding ethics?
Well, I gotta say, it's interesting to me that Vin, these decisions, whether they're getting a lot of attention or they're not getting attention, I feel like the public, to the degree that they pay attention to the court, has lost considerable confidence in the court.
Respect.
In part, if you're paying attention to the situation, that you've got at least one, if not more, particularly Justice Thomas, failing to disclose trips that he's received and spending on his behalf by a Republican mega donor. And then Justice Alito, it turned out, is flying around on a private jet to luxury fishing trips, blah, blah, blah. So, and politicians, elected officials, certainly, are supposed to be disclosing. And we know from George Santos that, perhaps that's not occurring in the way that but they are standards. There are none, or there were none, for the Supreme Court. And Amy Coney Barrett basically says, I think we should have a code of ethics. I think everybody should have a code of ethics. All of us justices should have a code of ethics. And here's what she said: so we can communicate to the public exactly what it is that we are doing in a clearer way than perhaps we have been able to so far. Why is that important? Because decisions are made of a significant import, even of the cases that, are supposedly low bar, in your opinion, David, and not say gay marriage or what have you. I mean, people's lives are impacted, and they're impacted by individuals who, act largely in secret, serve for life, and have no rules. Apparently,
why am I the example of the low bar?
Because you were there are these cases flying under the radar screen, but they're interesting.
They're not interesting. That's the thing. They're not interesting, but they're important, right? There's no, sexual innuendo. There's no scandal associated with it, but they're super important as far as the law goes.
So in other words, we're going to be boring the people that listen to the podcast.
We are, but that's why you two guys are here to spice it up. And of course, Liz is absolutely right. To have a Supreme Court that is respected by the public and their decisions are respected is of the utmost importance. And I don't think that's the case today because of some of these issues. Right. And so I'd like to spend a minute talking about it. I mean, the Supreme Court doesn't answer to anybody. They should, in fact, answer to themselves.
No.
And when Amy Coney Barrett says we need to have some standards, then I agree. And I think the Supreme Court amongst themselves should say, look, there's a certain low bar, whatever, the David Miranda level, we're not going to go below. And I don't even think they're reaching that level.
No, well, right now they're not reaching any level at all. But But I do want to, and the reporting has been fantastic. I have to say, my former brethren, ink-stained brethren, have been really doing very good work. And of course, then there are people who don't like certain justices and are probably ratting them out or what have you. Yeah. But I do want to just note, and I don't want to go too far down this rabbit hole because I'm sure we'll speak about it related to the state level, but this is where this whole separation of powers thing gets dicey, because you say, David, well, the court should really inflict some standards on itself. And I'm a member of the public, and I'm like, I don't trust those chickens in the fox and the hen house situation. Like, why should the Supreme Court? Why? Because these are the people who have been, hiding the benefits they've been receiving, and they're there for life. There's no check and balance. They're going to put their own check and balance on themselves, and then I'm going to trust that they are.
Who are you going to trust, Liz? You're going to trust the Congress? Do we want the Congress, who can't even decide who their speaker is going to be?
No, they did. They did decide that.
Oversee them?
It's a guy from the backbench in Louisiana. They did decide that. Is
that who we want overseeing the Supreme Court?
I don't know the answer. I don't actually really have the answer.
Here.
I don't.
Miranda warnings. We need answers.
Well, if the Supreme Court
maybe Vin has one.
No, I think if the Supreme Court had ethical standards, there would be justices on the court to be insisting that they be abided by. I mean, that's what happens on most courts, for crying out loud. It's not as though you have some law enforcement agency that's going over to the Court of Appeals and saying, oh, by the way, you must recuse yourself. Oh, by the way, you can't take that flight with your billionaire friend. They don't have that. But, most of these justices, they care about the reputation of the court. And I think there's enough of them that care enough that will say, look, we're bound by these standards. Let's take them seriously, for crying out loud.
Who cares about the Supreme Court is the Chief Justice, is John Roberts. Cares about the Supreme Court. And why isn't he setting forth standards about how the Supreme Court
I think
should
he's being
themselves?
why
isn't he? Control of that court.
I don't think the last year he seems to have gained an awful lot of control back at that court. But I will tell you one thing: he's pretty serious about the court's reputation, and he's made it clear.
He's lost.
We want ethics.
He lost Liz.
Brett Kavanaugh.
He has lost me. I'm sorry.
He lost Liz.
Well.
I don't know. I just want to say, I don't know.
I don't think Liz trusts anybody.
I do. My dog. I do.
Okay.
But so to be clear, but not alone in the house when it comes to.
I know. Look at
I guess the point is, when you get so far, I agree with you. I believe in the independence of the courts, and I believe that there should be a separation. But the problem is that when you've gone so far down the well and demonstrated that you have zero ethics, and then you're like, and now instituting ethics, why would anybody believe you? It's going to take a whole generation of replacement on the court for new people who then simply agree to hold themselves.
That's where I agree with the first part. The second part, I think there's still time now to make a change.
I'm not saying we shouldn't make a change.
Start.
Yes, we should start.
Why isn't our chief standing up?
He is standing up, but he also wants to respect the independence of his colleagues, I think. And he's probably doing a lot that we don't see. He's got Brett Kavanaugh on board. He's got Amy Coney Barrett on board. He's got Elena Kagan on board.
Well, all right, then he's got 5.
Yeah, so what he doesn't have, he hasn't had Alito and Thomas saying, or Gorsuch.
Worst actors.
Yeah.
Well, gee, I wonder why he doesn't have them on board, because they're like, we want to keep flying around with our buddies.
Right. Stand up.
We want to keep golfing at private locations. We want to keep fishing on great.
There's nothing wrong with golfing. There's nothing wrong with fishing.
Yeah, if you pay for it, there's nothing wrong with it.
But there is something wrong with taking a $250,000 loan that you don't repay.
Oh yeah. The RV.
Yeah, and then and not reporting it.
You know what we're talking about, problem. Liz? With the RV?
I do unfortunately know what you're talking about. Yes.
Yeah. So Thomas has this working man's $300,000 RV.
Right.
And he got a loan to pay for it, and then he never had to pay the loan back.
I just this whole thing is so distasteful. I just think the real issue is that it undermines the credibility of the court. And then when you have contested or controversial, I mean, I don't want to go over an old saw like Dobbs, but let's go over an old saw.
We can talk about Dobbs. Let's talk about it.
And social, what's interesting about Dobbs is that it's touched off a whole series of additional subsequent lawsuits based on legislative decisions
Right.
that and language changes that are hiding, what they really are, which is effectively abortion bans. That's what they are, bans on abortion.
All right, so you raised Dobbs, and I'm the
We've got that case
I'm
coming
the
up.
moderator here,
Yeah.
and we're talking about the 23 term.
Yeah.
We've got a case that we've got Dobbs in place, and now we've got this FDA versus Alliance for Hippocratic Medicine about the
Mifepristone?
mifepristone
Is that the
that's
way-
sent via the mail. And we've got a case that's coming up where they say because of Dobbs, you can't send this medication to somebody who might need it over the mail services.
And that's where I think the rubber is really going to hit the road with the court, because you know where the three liberals are going to go. They're going to say, no, you can't restrict, right, the mailing, the distributing of this abortion pill. On the other hand, I think that Roberts will probably join the liberals on this one, saying, look, we might have gotten rid of Roe versus Wade, but that doesn't mean we've gotten rid of all choice that women have had.
Or all of our laws.
Yeah.
I mean, this is a medication that has been in place for over 20 years. And what they're
Yes.
saying is that this is somehow, we're going to go back retroactively 20 years later and say, no, you can't, that was wrong.
Well, and mifepristone is not, just since, we're talking technicalities here, is not a late term abortion drug, right? It's only effective in a very early stage.
Mm-hmm.
So it's not, I do understand, again, you have conservatives who are and anti-abortion advocates who are really interested in having zero access.
Right,
That's
right.
what this is about. It's not, let's restrict access because, this and that, but that is really outside the realm of public opinion. When you look at the polling, you see that the vast majority, and you look at votes that have been taken since Dobbs,
Right.
When against candidates and even ballot initiatives that sought to significantly roll back abortion rights, they largely failed.
Yeah,
So-
but Liz, let's talk about that. What you've just said in particular, the Supreme Court is above public opinion polls.
Huh.
What we're talking about with this particular case is not a opinion poll. We're talking about FDA approval of a drug that's been in place for over 20 years. And whether the Supreme Court should be in a position of saying what the FDA has decided 20 years ago now should be overruled by the Supreme Court.
They do that.
It's
How is
much
that
more
different
than
from weighing in on the EPA or
That's right.
weighing in on
it's
immigration
gonna be the same-
reform
It's
or
going to be
weighing
the
in on
same
anything?
thing. I
It's
think
the
you're
same thing.
You're going to have justices saying, look, this is a huge decision, that the FDA has made, especially in light of our Dobbs decision. And we think that the people's representatives ought to be deciding whether or
Right.
not this pill should be distributed. I could see 2 or 3 justices saying that. I don't think they're going to get the majority because, like I said, I think that the chief judge and I think Brett Kavanaugh, at least those 2, will join the liberals.
Never
and say, no,
in my
FDA.
simple mind would I have conceived that Roe v. Wade after 50 years would be overturned. And it was. And now the conservatives are thinking, well, if we can get that, then we can get anything.
But I think Roe versus
No matter
Wade
how
has been on the
ridiculous,
rocks
and this
since
is
the beginning.
ridiculous from a legal perspective, is ridiculous.
Roe versus Wade has been on the rocks since the beginning. There's been a party, one of the parties has been against it from the beginning. And even liberals think that decision just went way, way, way too far. They didn't need to do that. They had
Well, that you have such a divided Congress. It's interesting to set what you're saying in truth is, there was a statutory fix was really where the decision should have gone.
That's right. Yeah.
It should have been go back and make it clear from a statutory perspective what it is that we're talking about when we're talking about people's bodily autonomy and people's right to make decisions within the context of their own health and with their medical providers' advice and counsel, right? But that's not what happened here. And so when you have all of these dichotomies of the conservatives and the traditionalists and the doctrinaires saying, well, we have to stick to the Constitution, and then, where it suits them, going outside the box on that.
So I'm hearing this is a bridge too far.
The FDA decision
to take away this
case?
to take away this is a bridge they've pushed as far as they possibly can, and they've put this case before the Supreme Court. It's too far. They've done too much.
I think you've got 5 votes on the court to say, look, we don't have Roe versus Wade anymore, but that doesn't mean you get to tell women that they can't have any autonomy with regard to their own body. You're going to go too far. It's going to be arbitrary. And we're going to say it's a violation of due process. I do think it's going to come down to Kavanaugh,
who was, circumspect in his comments related to the Dobbs decision, right? Yeah. He was like, he even said, there's a bridge too far here. Like, this isn't it, but there will be one, right? There will be a bridge too far. I don't know that he was specifically relating to abortion rights as he was potentially relating to, speaking of other things, which people feared that Dobbs opened up, like interracial or same-sex marriage, etc. But I think that he was leaving himself room in that decision to basically, go back and say, when I said that there was bridges that were too far, this is one of them. Yeah. We'll see. We'll see.
So the answer is, it all comes down to Kavanaugh on this one.
I think so. Yeah, I think so.
Yeah, I think so too, which is frightening, actually.
There's another case that, in my mind, is a bridge too far, right? So we've got the Bruen case regarding Second Amendment, regarding guns, which we've talked about here on the Miranda Warnings Roundtable, where, the court said, look, we're going to look at the law that was in place at the time, right? We've got these originalists, right? And so now we've got a case coming up, U.S. v. Rami, right? Rami?
Yeah.
Rami, is that right?
United States v. Rahimi. It has to do with someone who's accused, at least, of domestic violence. And the question is whether or not having been accused or even convicted of domestic violence is enough to strip somebody of what the court's saying are the Second Amendment rights.
But when you're looking at the Second Amendment, according to the decision that was written last year, you got to look at what the laws that were in place at the time. And unfortunately, at the time, we didn't have a lot of laws regarding domestic violence in the 1700s. Right. So the question is, can gun rights be restricted based upon someone who's been engaged in domestic violence?
Right.
And it seems clearly that the answer today would be, yes, we should restrict guns to people that are engaged in domestic violence. However, the question before the Supreme Court is, if you want to follow the law as you've stated it, what restrictions can there be on people who are engaged in domestic violence? That 200 years ago, those laws weren't on the books.
But I don't think everybody on the court, well, I'm sure everybody on the court doesn't buy that. I mean, that's a Thomas thing, a Gorsuch thing. You have to look back in history and see, were there any kind of restrictions back then? I don't even think there's a majority on the court for that. I think a majority on the court is going to say, if this is in fact a fundamental right, that is to bear arms, we apply, and we should be applying to that fundamental right, the same test we apply to every other right. Is there a really, really, really strong reason for the government to be abridging that right, curbing that right? And is this the way the government has to do it, right? The compelling interest, strict scrutiny test. This nonsense about you go back, to 1792.
Well, you say it's nonsense, and I don't disagree with you, but the Supreme Court apparently does.
There's a couple
decisions.
Of them. 2 or 3 of them have said that.
Majority decisions.
Yeah.
This is not a fringe opinion
It
anymore.
is a fringe.
It's a majority opinion, Vin.
First of all, if we actually analyzed all the cases based upon this nonsense, what does history and tradition show us? We wouldn't have any of our landmarks. It is so absurd. It really is absurd. Women wouldn't be protected by equal protection. We'd still have racial segregation. We wouldn't allow interracial marriage. I mean, everything would go. It's ridiculous. It's a ridiculous test.
Agreed.
I don't think we should take it as seriously as I think some of us are, simply because a couple of justices on the court wrote that stuff in their
I don't
opinion.
think it's serious or right, but I feel like we've extended the ridiculousness now with these cases. That's what I think this term, the theme of this term is how far can we extend
I think
the
you're right.
ridiculousness of the decisions of the last term.
Yeah, right. And it's not even so, it's not even so much what the ultimate result is, but how the Supreme Court goes about analyzing these issues and resolving these issues. What methods do they use? Don't come up with this brand new test suddenly, in 2000 or 2020, whenever the hell they came up with it, that you have to look back to 1792 and see if there were any laws back there. I mean, what about the fact that if society has an extremely important reason for doing so, shouldn't society be able to do that? That's typically been the test, right, on fundamental rights, ever since the Supreme Court gave a damn about, civil rights and civil liberties, which, beginning in 37 and then an awful lot during the 60s. But that's been the test, not this you look back to see if there were any laws back then.
Where did that come from?
Well, it's part
Where
of
did that
this.
come from,
It's
Vin?
part of this originalism stuff. You look at the Second Amendment, and were there any restrictions that the framers of the Second Amendment were thinking about when they wrote this? And if there weren't any such restrictions, then they weren't thinking about those. Of course, the whole
they weren't.
The whole interpretation of this Second Amendment that the court's given, we know is a damn lie. I mean, the Second Amendment is a protection of states against the federal government. It doesn't have much to do with an individual right to bear arms. But that's the law anyway right now from the Supreme Court.
Liz,
I got nothing on this,
you
man.
could, all right. Well,
yes, you do.
We
I
got
can see
no.
that.
That's fine. We got plenty more. I want to talk about there's a couple of redistricting cases that are coming up.
Oh, Lord.
And I don't even want to talk about New York.
What is that? What is that? What do you mean, oh,
Redistricting?
Lord. What is that? I'm talking to Vin. His response. I don't understand.
Oh, Lord?
No, because the court, you don't know where the court's going with this stuff. First they say, we can't touch it. Well, maybe we can touch it if there's this.
We're talking about redistricting.
Yeah, redistricting.
Right? Yeah.
And
Okay.
then several state courts, when they get the cases back from the Supreme Court, say, we can come up with a standard. That's pretty easy. Did they redistrict in such a way to deny certain voters, the power of their vote, dilute the heck out of them?
So
That's a standard.
Here's what I'm seeing. Simple understanding of the law is that redistricting based upon political affiliation is perfectly constitutional. If you do it based upon race, it's not constitutional.
That seems to be what the Supreme Court case law is so far.
Yet, that's not enough.
And that's not what the states are saying.
The
The
states
state Supreme Courts are being much, much better about this than the Supreme Court. And there is no doubt in my mind, ultimately, the Supreme Court will embrace what many of these state courts are doing.
Well, we've got a case coming up in a South Carolina case.
Yeah.
Alexander versus South Carolina. We have another case from Mississippi,
Or-
Alabama.
Alabama, yeah,
Alabama.
because the Supreme Court said, yeah, Alabama, give me a break. We know that you redistricted the way you did in order to dilute the black vote in
Right.
Alabama. So the case went back, and what did Alabama do?
They said, well, we know we did it, but just
We'll change it a little, we'll tweak it a
Later.
little,
later.
but we have the same problem.
We'll change it
We
later.
have the same problem. And then the lower court said, hey, look, Alabama, that's contemptible what you did. We told you you couldn't dilute the black vote.
And now
Right.
we've got the Alabama vote, which actually the Supreme Court actually kind of did the right thing. I'm going
Yeah.
to say,
Yes.
right? Where they said, look, no, we told you guys you can't do this, and you did it anyway. South Carolina, we said, look, we told you if you say it's party affiliation, it's okay. If you say it's race, it's not.
And that's what it
and
looks like.
they couldn't bring themselves
Right.
to say that it's only party affiliation. And so now it's back at the Supreme Court, and they're saying, well, we really didn't mean it.
Yeah. Well,
Right? Is that right?
Right. Yes, you're absolutely right. But if members of the Supreme Court, other than the three libs, say, look, give me a break. We know darn well that this partisan gerrymandering, that's just a proxy for racial gerrymandering. You know that. You know this is going to be the result, and you do it anyway.
Yeah, but it's not even that it's a proxy. It's that you could still accomplish what you want to accomplish by using the party affiliation. But they said, well, that's not quite as good as the racial one.
Right, but if they use the party affiliation,
it's okay.
In such a way that, for instance, it used to have 2 districts, majority black. We cracked them and packed them to make sure that there's only one, because we think all the blacks vote for Democrats. I don't know. What's the difference between that and racial gerrymandering?
Well, nothing. But I'm sorry, just nothing.
See, there we go.
Yes.
Nothing.
Can I just
Good.
say,
Shed some
here's the
light
thing.
on
I
this.
find this is so interesting, this whole discussion, because we spend so much time talking about how, like, well, and I don't mean to be beating the dead horse here, but like, oh, there should be a division and a separation of powers, and yet then there's going to have the judicial branch weighing in on legislative redistricting that results in the election of one party over another, who then subsequently make decisions that influence the judiciary. I mean, all of this is so clearly a web of interrelatedness that to suggest like, oh, the judicial branch is absent of politics is just horse feathers. Like, it's ridiculous. And this whole thing, I mean, again, when we get back to the discussion related to ethics, like, well, what is, if we're not going to have the fox guarding the hen house, then what is the actual answer? And I don't have the answer, and I don't have the answer here either. I don't know a better, when we say, well, democracy is broken, but it's better than the alternative, which would be like socialism or.
Yeah, but you know what the answer is, Liz? I think you do know what the answer is. The answer is the checks and balances that our founders set forth, right? They understood that people were political animals and that they needed to have those checks and balances. And when we get rid of those, then we have trouble. We can't have any one of those entities on their own. Let's just be
clear. There's such a chain here. Like, the legislative redistricting results in the strength of the election of one party over another. At the state level, that creates a bench for the congressional level. At the congressional level, that subsequently creates a bench for the Senate. The Senate, which rides herd over the confirmations to the Supreme Court. And so arguably you can follow a very clear and logical path of self-interest in legislative redistricting cases.
People are self-interested. That's why we have checks and balances. But the offensive part, when we're talking about South Carolina, for example, is that South Carolina's, it's pretty close, right? Maybe it's not super majority, but it's a close election. But then you have, it's like 14-2 when it comes to Congress. Right. And that's not a fair representation. And what the Supreme Court is saying, well, look, when you write these things, there's certain things you can't go outside the lines. And that's not enough. They're going outside the lines.
They are going outside the lines. I mean, one item of hope is the Supreme Court's decision last year, Moore versus Harper, where there was this really extreme doctrine, the independent legislature doctrine, which was that state legislatures can redistrict any way they want, and they don't have to pay attention to the state courts or the state constitution. Okay. And the Supreme Court threw that out. And actually, that one was 6-3, because Roberts, Kavanaugh, and Barrett joined the liberals to say, no, state courts can impose state constitutional and state legal requirements when you redistrict. And that's really, really important.
And I got to say, these cases are so boring, but so important because
I don't think they're boring at all.
well, you don't. This is why I'm talking to you.
Well, I'm a nerd,
Right.
yeah.
So, but for most people, their eyes are glazing over. How many people do you think made it through the 18th minute of this conversation about redistricting?
Yeah, they
It's-
tuned in for ethics and they were like,
Right.
all judges are not ethical.
Ethics,
and then they
something,
tuned
give me
out.
something sexy, Liz. Give me something sexy. But it's so important, right? We just saw what happened in Congress where it's a 5-person majority. Each one of these decisions could turn whether we have abortion rights or not,
That's right.
whether we have funding for Ukraine or Israel. All of these are so super important, and when you have a state like South Carolina, for example, which is pretty evenly divided, and it's so slanted towards one party, that's a problem.
There's a bunch of states like that. North Carolina is another one that's been like that, right?
New York.
Yeah. Well,
Well, we've got redistricting issues in New York, which we're going to talk about next time. I'm going to give a little teaser. We're going to talk about next time. But in New York, we're going to be subject to the New York State Constitution.
that's right.
And this is not going to the Supreme Court. We have to decide
Right.
amongst ourselves.
That's right.
But
That's
these other
That'd be
issues
great.
go way beyond state constitution. It's federal
That's right.
constitution. It's violative of the one person, one vote. And this case, this South Carolina case, I'm just going to say we need to keep an eye on
yes.
because it's hugely important.
Absolutely. And I think there's going to be some shifting of votes in these redistricting cases at the United States Supreme Court, because they realize that for us to say, well, we can't do anything about it, just allows such extremely partisan gerrymandering. And then you say, well, we did this purely because we're Republicans and we want Republicans to have more power. Well, we really didn't know that what this was going to do is dilute the heck out of the black vote. Oh, give me a break. I mean, even these guys up at the court, even Gorsuch and Thomas and Alito. I mean, how much could they possibly swallow?
So, all right, I want to move on, but the South Carolina case,
a biggie.
is that going to be upheld? Is that going to pass muster?
Did they already have oral arguments on that?
Not yet.
They didn't?
I
Then
don't
what,
think so.
then what am I thinking of?
I don't think the South Carolina case had arguments yet.
Okay. Maybe the court below. What did the court below do? Remind me. Did the court below say it was okay what South Carolina did?
I don't think
I
it's
don't
okay.
remember.
No, it's not okay.
Yeah. Well, yeah.
All right. I want to talk about another boring case.
What?
Liz, I know you're going to be excited about this. This involves fisheries.
That's a huge one.
You're a friend.
That is a big one.
It's a big one.
That is a
You're
big
a
one. It
friend
is.
of all animals. I know,
yeah.
Liz. So
Fish are not animals.
fish are
I
an
mean, they're
animal?
Fish.
Fish are not animals.
Fisheries.
What are
I mean,
they?
they
Plants?
are, but they're, okay, whatever. They're amphibians. Okay, yeah,
Yeah, and
All right.
yeah.
go on.
Yeah.
Do they have
Fisheries.
feelings?
Go on. I'm riveted.
The fish have feelings?
Feelings, they do. I believe they do. But can we just, I'm sorry, can you just go on?
So
with the
this
rifle?
case.
No, this is an important case.
This is the most boring and most important case.
It's not that boring.
It's pretty boring.
What's underlying the case is not boring. Again, it's going to be.
We haven't even talked for 10 seconds. I'm already bored. But
wait, whether an
We haven't
agency
said anything yet.
whether an agency should have the power to do what this agency did.
This is whether an agency can have the power to
Right.
enact things without Congress saying you should enact this,
That's
right?
huge.
So there's a regulation that says these people that go fishing need to be regulated by the federal government. And the question is, when the federal government regulates, who pays to have the regulator sit on their boat
That's right. Yeah.
and watch what they do. And so it's the federal law allows the National Marine Fisheries Service
That's right.
to require fishing vessels to carry federal monitors to prevent overfishing.
Right.
We can't overfish. So we can all agree there shouldn't be overfishing. What we can't agree on is who monitors it
That's
and
right.
who pays for it.
That's right.
Now,
Why
this
is this interesting?
sounds boring,
No, it is.
but I'm going to tell you
Exactly.
why it's important.
It's
Because
very important.
if the agency says
That's
you
right.
guys have to pay, and this lawsuit says no, you can't decide who pays. It's up to Congress.
And it's another question about how much power agencies should have, and it's another excuse, I think, to whittle the power of administrative agencies.
Clearly,
Yeah.
this is a huge
It really
under
is.
the radar
Yeah,
case.
That's right.
That if it's rejected, if they say, the agency can't say who should pay, which personally, I think, quite honestly, why should the fishermen have to pay for this? Quite honestly, I don't agree with
Yeah.
that. But I also don't agree that the agency's regulations should be undercut.
Right.
If this is undercut, the agencies have no teeth, zero teeth. They're like a fish without any teeth.
Yeah.
Well, well,
Well, according to Liz, they're not even animals, so who cares?
all fish have teeth. No,
Do we only care about? We don't care about amphibians. Is that it?
all fish have teeth. Wow, who
Do
knew?
we care? Do we care about fish?
I
Liz?
think we do. Yeah, we do, and they all have teeth.
Do they?
They're our fish animals. Our fish animals.
Yes.
Yeah, fish
I'm
are
going to
animals.
say yes. They're not mammals, but they're
They're
animals.
aquatic vertebrate animals.
Yes.
Yeah.
All right.
All right, there you
All right,
go.
So
So with all due,
I've turned
I
you.
mean, I see this as
Huge.
the test case by which the anti-government types, the conservatives who don't like big government, utilize this as the camel's nose under the tent to then subsequently go to other agencies and say, oh, and you can't do this, and you can't do that, and you can't do the other thing. So
I like the camel. I like the camel part.
Well, and we're all about animals here on Miranda. That is concerning. I agree. But my question is, so based on the precedent, I would imagine there would be subsequently, it would touch off an avalanche of other lawsuits challenging other agencies.
Oh,
It would
yeah.
not-
Yes.
There are.
Yeah, that's the point.
There are.
That's the whole point.
There are. Yeah. There's now this major questions doctrine, which basically says if the administrative agency is doing something that has a huge impact, that really ought to be done by the Congress and not by the agency, unless the Congress specifically gives them that particular power. That's what the court has been using, the major questions
Yeah.
doctrine.
So Liz,
And I
mean,
think there's merit. I think there is merit to that. I don't like what
There is
they've
merit.
done with it, but there's merit to it. If
but
it's a big
merit,
enough
but it's
question,
crucially
the
important.
people's representatives ought to be
right.
doing
So
it.
Congress has
Oh, if
said
the people's representative could get out their damn way and do anything in particular, that would be great, Vin.
But they've deferred to the agencies on this. The agency
Right.
to decide.
That's
Well,
what
And
part
if-
of that, you really doesn't this get us back to the conceptual foundational conversation about what the responsibility of an agency is? They don't just push pencils. They are supposed
No,
to
right.
implement statute. They make regulatory
Right.
decisions.
And they're supposed to be doing that independently based upon their expertise, based upon science, and immune from political pressures.
Right.
But the other side of that is when you say immune from political pressures is that they're not accountable. So, you have, there's
But
two
this-
different arguments.
This fisheries case, if this is decided that they don't have the authority to do this, then we're going to be in a really tight spot, because then what do these agencies have the authority to do at all? Nothing.
Well, they may have in this case, for example, the fisheries service, the court may say, does have the authority to require that there be federal monitors, but you don't have the authority to say that you, the fishermen, have to pay for these monitors. You know, I think that's a perfectly legitimate way to resolve this issue.
I gotta say, Vin, this is like a threshold case, though. This is like a Marbury versus Madison case.
Oh Lord!
This
see
is
what we've done.
This
here?
is
I think that's a
Liz,
little
do
bit
you
of,
see-
no.
do you
This
see
is.
what
I'm
we've
not
done?
overstating anything when I say that this is the Marbury versus Madison. They said, "Well, no, we're not going to intervene, but we have the right to say that we're not going to intervene." Right? So in this case, if you say you don't even have the right to decide, then what can the agencies do if they can't do anything unless the Congress says
you have a
says they
right.
can?
You have the authority to say that the fishing vessels must have a federal monitor, but you don't have the authority to say. And by the way, you guys have to pay for it.
I refer you, Professor Bonventre, to the case of Marbury versus Madison as my authority.
And you know, if these conservative textualist justices really believed in this nonsense, they would have to undo judicial review because it's not in the Constitution. It's not explicitly there. It's just not there.
Well, as long as we get the votes,
Yeah,
doesn't matter.
yeah, that's right. And the justices, you know, are very jealous of their power. They're jealous of their power. Oh, we should stay away. We should stay. Yeah.
well, then
That's
the
exercising
justices
the
should
power.
run for Congress.
Right. They should. They should run because they're acting as politicians, right? I'm okay with politicians being politicians, but judges
But
should
not
be
these guys.
more
No,
judicious.
these guys.
Liz,
That's why it's a terrible court.
we're going on.
Back to the fish discussion, because that was
Yeah.
more interesting to me.
You like the fish? Yeah.
No, not the fisheries, the discussion about fish.
Yeah.
Just to be clear.
Okay.
Fish, do they have teeth? Do they not have teeth? Do some of them walk on the land? Who knows? Do you still call them a fish if they do that? A fish out of water is still a fish? That's
don't know.
interesting.
Well, then it's an amphibian.
Right.
If you got a fish, right, but it can be on land and in water, that's an
I don't know.
amphibian.
I'm surprised nobody is sued.
Frogs. That's what a frog is.
I was going to ask Liz if she had a case. Do you have a case you want to
don't
talk? Because
have
I
a
got one
case.
more.
Who would
I got one more.
sue?
I
Do
got
you
one
have
more
any case?
I got another case.
Do I have a case? No, my job here is to provide levity. That's my gig
Oh,
here.
all right. Do you have a
What other
well?
Marbury versus
Tell us
Madison?
what's
like
more
case
boring
do you
than that one. I can't wait.
More. Well, hold my beer.
Oh,
Because I
oh,
got-
David.
I got a more boring one, but quite honestly, almost as important. Consumer Financial
Oh, yeah.
Protection Bureau, right?
Yep.
I mean,
Oh,
I lost
geez.
you at consumer, right? I
Oh.
mean, you were.
Oh, that's the one that has been argued already.
It's an independent
And the
agency.
justices seemed very, very skeptical of the argument against the way the Financial Protection Bureau has been funded. I mean, no, they're skeptical about the challenge to that.
Yeah. So
Yeah.
right. So we got the CFPB,
But it
right?
is the Consumer Financial Protection Bureau, and
Can we get to the punchline here?
They're
What
saying
other
that
things do?
they're not funded by Congress. They're funded by the Federal Reserve. So if Congress didn't fund them, they're not valid, is what they're saying. So the Consumer Financial Protection Bureau, which is an independent agency which
Right.
protects consumers, the argument is they're not even valid and they shouldn't be funded
Right.
because Congress didn't say they should be funded. They're funded by the Federal Reserve Board.
Right.
And that's the issue. Is anything that's not funded directly by Congress valid? Right?
Right. I mean, that's the question in the case.
Who
And-
funds the Fed?
Well, I think that's the same kind of thing, and that was one of the questions that was.
I
asked
send them
by the
like $20 a
justices.
month just
Yeah.
to do the right thing. But
Well, the Consumer Financial Protection Bureau. Remember, there are several members of the court that don't like it at all.
So the
Period.
Federal Reserve is not funded by congressional appropriations. Its operations are financed primarily from the interest earned on the
That's right.
security loans.
Yeah. Yeah.
So it is actually a truly independent entity.
Yeah. Yeah. Well, the Consumer Financial Protection Bureau is not completely independent because their officers can be removed
By
by the president for political reasons. That was one of the things that the court had decided a few years ago, which really diluted the strength of the Bureau. I mean, there are some members of the court that don't like this Consumer Protection Bureau, obviously, because it gets in the way of their friends making money. I mean, come on.
And they're trying to undercut it by saying you're not being properly funded.
That's right.
Right.
That's
and
right.
so
You're
I
not
think
being
this
properly funded.
hugely
Okay,
significant case. This is
I
a
was
hugely
I don't
significant
see it. You
case
tell
because
me how many other entities fall under the same funding scheme as this
Many.
one? How many?
I don't know the number, but a lot. It's a
I
lot.
don't know. What is the danger here? The danger is that other entities subsequently get called in on the carpet, lose their capability of being fully independent.
Oh, I
Yes.
think if the court rules against the Financial Protection Bureau, I think we're going to see more lawsuits to dilute the authority and financing of a lot of these agencies.
Yeah, I mean they're
So it's
not going to
basically a
operate without
subset-
funding.
It's a subset of the conversation we just had, which is a diminishing of government authority
Yes.
writ
Right.
large, right?
Yes.
We don't like what this agency is doing, just like we don't like what the EPA is doing, just like we don't like what the IRS is doing. So we're going to cut their funding.
Keep an eye on this case because if
Yep.
this one,
Yep. I
but
think
you're
right.
saying, Vin, and this is somewhat medium comfort. You're saying this one's not going to carry the day.
I don't.
This is
I don't think
also a
the
bridge
challenge
too
to
far.
this one's going to carry.
This is
the
a
day.
bridge too far because it's
Right.
going to mess up how we run our government.
I have to say, I think the way you've actually wrapped up this current term, a bridge too far, I think that's exactly what's going on at the court now. They're
Maybe you
thinking,
should
are
ask for your article
they-
to be retitled.
We
they
should change
going
it.
too far? Well, no, my article was a look back. Only because some commentators were saying, "Oh, it's really not politically divided." I mean, I don't know
The
what
title
these
of
people
Vin's
are
article was "A Bridge Too Close."
Yeah.
So Vin actually, I'm gonna memorialize this because Vin actually gave me a compliment. He said I actually wrapped it up.
No, I
perfectly.
think you wrapped up the theme for this
Why?
current
What I
term.
want to know.
And I
is
want to give
why-
Liz a chance just to rain on this parade here.
No, actually, I was going to say I have this weird craving for sushi, and I'm not even sure why that is.
Because of a fish case.
The
probably.
the fish case has left me in a place where I'm thinking that some sushi would be good.
Yeah, she's not a carnivore, but fish are not animals, so she'll eat a fish.
No, I eat meat.
So this Supreme Court case, this Supreme Court session,
Yeah.
super boring,
Absolutely.
super important. That's
Yeah.
my
Oh,
that's
yeah.
my view.
Absolutely.
And next time on Miranda Warnings,
That's our tagline. Miranda warnings, super important, super boring.
I
Check
don't
back
know.
next time.
There was nothing boring
I think
about
you
it.
nailed it. I think you nailed it. I think you nailed it, Liz.
Check back next time when we
Or
ask
some-
Vin,
even-
when our commentator Vin says,
Even you think this
This was
week
boring.
you think this week was boring. Wait till next week.
Oh no, it's
It's going to
great.
be even more.
gonna be
Because we're going to be talking about New York Court of Appeals.
That's right.
dude,
Next
that
month.
is
Next
interesting
month.
stuff. There is intrigue there. Like,
Oh yeah.
Oh,
No
my
idea.
Oh
gosh.
yeah.
Oh my gosh. Stay
So
tuned.
good.
Stay tuned. Love you both. This
Okay.
was awesome.
Love you guys.
This
Thank
is I think this is gonna go viral. I'm pretty sure.
you. Yeah.
I
I hope it gets to Thomas, Gorsuch, and Alito.
think
Yeah.
this is gonna change minds.
I think the law clerks are going to say, "Hey, Justice,
Wow.
you really need to listen to
A
this
little less
podcast."
boring.
really needs. This is
Thank
going to
you.
make it. This is gonna make, is this,
Thank you, Liz.
This is being recorded, right? My dog has made so many cameos in this.
Sushi tonight.
Oh yeah.
Sushi tonight. This has been Miranda Warnings, a New York State Bar Association podcast. You have the right to subscribe, rate, and review.